Advocate Buthelezi currently practices as an advocate, and she's frequently invited to discuss various legal topics on different radio stations. So today she'll be sharing her knowledge on company law, primarily her focus and the topic that she'll be sharing with us today is piercing the corporate veil. I can't wait to hear all about it. Advocate Buthelezi, are you here with us?
Afternoon, Advocate Makola. Yes, I am present in the meeting. If I can just be given a moment just to properly log onto the platform. But yes, I am present. Thank you.
Okay, because thank you. Yes, now we can see you. Okay, colleagues, as you know, kindly please switch off your mic throughout the presentation, and your camera off. And then Advocate Buthelezi will then start her lecture. And then at the end of the lecture, you can then if you have any questions, you'll be able to answer them. Welcome and thank you very much. Samantha, over to you.
Thank you so much to our colleague and a very good friend of mine, Advocate Makola, who's also a member at the Pan-African Bar Association. Ladies and gentlemen, firstly, we'd just like to take this moment and this opportunity to, and on behalf of PABASA actually, to say thank you so much for taking the time to join us and to just, get some insights on today's topic, which, by the way, will be very focused on an aspect, a very heavily researched aspect of company law in South Africa. And as you would have noted on the poster, it's the concept of piercing the corporate veil. Now, why this concept? Just, to give you a little bit of a background. Well, this concept, like I've indicated, is a concept that is heavily researched, yet it still has a lot of gray areas in our law. Is really an aspect of our law that still needs a lot of development because, there's not a single unified approach that can actually inform the courts when to pierce the corporate veil. So in our jurisprudence, both in common law and in terms of our statutes, we still very much in our courts struggle to basically ascertain when the courts are justified to pierce the corporate veil. Now, I know a lot of our members we are joined by members and non-members this afternoon. So we will try and keep this discussion at a very basic and a very broad overview of the concept. We will not look into detailed discussions, but rather a broad overview of it, just so we all have a contextual background and at least understand the concept insofar as it applies to our jurisprudence in South Africa. Ladies and gentlemen, once again, welcome. And without wasting any more time, like my colleague has indicated, my name is Samantha. I am a practicing advocate here at the Pan-African Bar Association of South Africa, very popularly known as PABASA as well. And yes, we'll be discussing the very foundational principles of our company law, particularly with reference to the concept of piercing the corporate veil. So let's get right into our discussion. Ladies and gentlemen, just house rules before we proceed. As Thuli had indicated, we would appreciate questions to be reserved for the end of the segment, just so we can have a bit more control as to how this discussion basically unfolds, and just to make sure that we do cover the critical concepts that will at least make this experience wholesome. So with that being said, we'll go right into our discussion today. So for those that don't know, our company law in terms of legislature is regulated in terms of the New Companies Act. And for citation purposes, that would be the Act 71 of 2008. It's the New Companies Act because it was developed later. It came into effect around 2011, where we basically, in this act regulates basically companies. So Section 1 defines what a company is. Section 1 of the 2008 defines what a company is, and it just says it's a juristic entity basically that is incorporated in terms of the provisions of that act. So what it means essentially, if we break it down, any entity, any juristic entity that is that's basically incorporated, and we'll come into a short discussion about what incorporation entails, at least in the context of our discussion, and for purposes of our discussion today, we'll go into the discussion of what incorporation entails. But Section 1 just says it's any juristic entity basically that is incorporated in terms of the provisions of any provision basically in terms of this act. So with that being said, now we'll go into the discussion that pertains to what incorporation entails. And we still look at the same act, but the provision of section 19.1. 19.1 basically tells us that upon incorporation, a company becomes a juristic entity. Now, what does that mean, ladies and gentlemen? Becomes a juristic entity in that it becomes separate from its members, and its members, by members, I mean shareholders and directors. It becomes separate, and by separate, I mean that it becomes its own juristic personality that is capable of acquiring rights and obligation in its own name. Now, maybe if I can just give you the legal consequences of what separate legal personality entails, insofar as incorporation comes into effect, or at least in the context of incorporation. Number one, incorporation occurs or happens when a company is registered with the CIPC. So to basically unpack it a bit further, when we go and register a company with the CIPC, whether it's the directors or whatever, there are different corporate structures or corporate entities as defined in our act, but that's not the purpose of our discussion today. We're just going to look at it from an overbroad or an overview perspective. But upon incorporation or upon registration, a company becomes a juristic person. And the legal consequences that flow from that, number one, the first and most importantly, the concept of limited liability comes into play. Limited liability, simply put, ladies and gentlemen, simply means that the shareholders and the directors of the company cannot be held liable for the obligations and the debts of the company. And this also is reflected in the renowned case of Solomon versus Solomon, which, by the way, is the case that informs the founding principles of our company law, that a company is a separate juristic person and juristic entity capable of acquiring its own rights, acquiring its own, and obviously its own obligations. And the essence of that simply means that by mere virtue of someone being a shareholder or a director in a company does not imply that those people now become liable for the debts and the obligations of the company. So in essence, what I've unpacked so far, just so we are all on the same page, is that number one, to look at the regulation of our companies in South Africa, we reference the Companies Act. Of course, there are some entities that are not regulated in terms of the Companies Act, such as business trusts, but that's not what we're going to be discussing today. But broadly speaking, from insofar as the context of Act 71 of 2008, which is also called the New Companies Act, that makes reference now to what a company is for purposes of our discussion today. So that we'll find in the definitions section of the Companies Act, which is section 1. And then section 19 informs us what the legal status of a company is. And simply put, once again, it just means that a company becomes a juristic person capable of acquiring its own rights and also incurring its own obligations. Now, how do we put that in? How do we explain what I've just said in very simple terms, or to demonstrate what I've just discussed? Well, if company A goes into any transaction with any other creditor out there, that creditor, its rights are enforceable against that company and not its members, not its shareholders, not its directors. And that is now the embodying or the foundational principle of our company law in South Africa, separate legal personality. And from separate legal personality flows the concept of what we call limited liability. And that now protects the members of the company from any liability, which means they cannot be held personally liable. In fact, if anything, it's the company that will be held liable for its debts, for its obligations in terms of this general principle. So those are the founding principles before we go into the concept of piercing the corporate veil. Those are the founding principles that are essential to understand, because then you'll understand that in applying the principle of piercing the corporate veil, it's not actually in itself a general principle, but rather an exception to the general principle, and you'll understand why. So I hope everybody has been able to follow thus far. And if not, I think I'll just take a hint on my phone from my colleagues if I'm going a bit too fast, because I was warned not to go too fast during this lecture, just to ensure that we accommodate everybody. So ladies and gentlemen, why piercing the corporate veil? Why this concept? One may ask. Well, it's actually a metaphorical concept in our company law that just, it's there to create a demonstrative effect, just to show you that once a company is incorporated, there's a veil that's created between the company itself and its members. And remember, when we say members, we can be referring to shareholders or directors or both, depending on the circumstances. So that veil basically just illustrates that the company is separate from its members, and therefore the duties, the liability, the assets, the profits, whatever the case may be, they accrue to the company and not the members. However, if you know anything about our law, or if you are in practice, you'll know that with a general rule, more often than not, there are circumstances where the courts will, or at least what we call exceptions to the general rule. And that's where the concept comes in. Now, before we even discuss what piercing the corporate veil entails, at least in the jurisprudence of South Africa, I think it's also quite important to distinguish the term itself can be piercing the corporate veil, and sometimes it's interchangeably used with the concept of lifting the corporate veil. And although they're very similar, there are some distinct features that pertain to those two concepts. And I think I just maybe want to just quickly outline those just so that we are in understanding. In our jurisprudence, yes, they're used interchangeably, but like I said, it's important to understand the distinguishing features of those two concepts, because in actual fact, they are different, and their consequences that flow from the application of those two principles can also differ from time to time. So when we refer to lifting the corporate veil, that's usually when the courts just basically think about it that way, think about it in a way where it's, how you would sort of picture it. The veil would be lifted, but the purpose of that is not necessarily to impose personal liability to the directors, but rather to for the courts to consider the members of that company or who is behind that company. So the court will then usually lift the corporate veil to ascertain, and maybe that may be a factor to determine when the court is presiding over a matter or adjudicating a matter to make a just and equitable finding. So that's lifting the corporate veil. Now we come to piercing the corporate veil, the very core and crux of our discussion this afternoon. Ladies and gentlemen, piercing the corporate veil basically means that there are instances, like I said, it is an exception to the general rule where courts will obviously very much hold in high regard the concept of separate legal personality and also the protection of limited liability to the members of a company. And now piercing of the corporate veil then kicks in. In South Africa, piercing of the corporate veil can be applied in twofold. There's common law piercing, and there's a plethora of cases that have guided our courts in ascertaining or establishing when it's justified to pierce the corporate veil. We'll not necessarily go out today. We'll just do a very simple case discussion, basically, at the end of me just having this discussion with you, just so I can give you an example of how courts approach this concept of piercing the corporate veil, and how and why it's actually really difficult for courts to always exercise their discretions when it comes to the concept of piercing the corporate veil. So with that being said, as I've indicated, piercing the corporate veil can take the form in two ways. It can either be in terms of common law piercing, which is case law after case law, where even comparative analyses have been done with foreign jurisprudences to ascertain when courts can actually be justified, or at the very least, to create some form of uniformity when it comes to assisting and helping the courts determine when it is justified to actually pierce the corporate veil. So that's the one aspect. The second aspect, ladies and gentlemen, is our statutory piercing, and that is governed or regulated in terms of the provisions of Section 20, subsection 9 of the Companies Act. And that says, basically, long and short of it, that basically refers to instances where the court would be justified to declare that a company is actually not a juristic person, and as such, the company and its members are actually treated as one and the same thing. And the effect of that thereof is that the members of that company will be held liable for the debts of the debts and the obligation of the company. Now, as I've indicated, it's an exception to the general rule. So what does that mean? There are instances, and obviously there are requisites that would need to be fulfilled for the courts to actually then invoke that exception and, in essence, pierce the corporate veil. Ladies and gentlemen, it is, like I indicated earlier on when I started the discussion, it's a very, 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 very tricky concept for our courts to actually use and apply in various situations, because for example, I'll give you an example. In section 20, subsection 9, the provision actually says that, well, courts are actually they can exercise their discretion in instances where there's unconscionable abuse. Now, what is unconscionable abuse? If you go back to the provisions of the Companies Act, the Act 71 of 2008, the Act doesn't actually even define what that constitutes, or in what instances the court will then obviously come to a finding that there is unconscionable abuse. So what does that mean? The courts now are faced with a situation where they have to go and apply the meaning of that term or that phrase in the ordinary sense. And you can only imagine how broad that application can be. And that is part of many other reasons why the courts actually find a lot of difficulty in applying this principle. In actual fact, a lot of the cases, when we look at common law piercing, a lot of the cases actually, you'll find in the judgments that a lot of the cases actually say courts are not very ready to pierce the corporate veil. In actual fact, some cases like Halsrieta actually say there's we will sorry guys, just on a side note, we will try and provide the cases that I refer to, at least the ones that I will mention in our discussion, just so you can have a read and have a better understanding in case you might have missed something that I would have said. So with that being said, a good example again will be the case of Halsrieta, where the court actually said the veil must only be pierced as a matter of last resort, which means that the court must have actually applied every other legal principle that is applicable, or that the court can actually use in assisting its adjudication to, instead of piercing the corporate veil. So in other words, if there's something else that or another legal principle that can be applied, rather that than actually piercing the corporate veil. So more often than not, courts find themselves very, very, very hamstrung when it comes to this principle. And this is exactly why it's a very high point of not just discussion, but also research, not just here in South Africa, and in consideration to foreign jurisdictions, which also, by the way, struggle with finding unified approaches when it comes to this concept. So with that being said, ladies and gentlemen, as I've indicated, it's an exception to the general rule, and as such, courts are just not readily available to pierce the corporate veil. I'm going to, I think for purposes, like I said, I will do a very short case discussion on one of the cases in here, very recent case actually, for that matter. And just because in the interest of time, and also trying to make room for questions to be asked at the end of this segment, I'll just keep to one case. And that is a Supreme Court of Appeal judgment. I think a lot of you guys might actually be in the know of this case. It's a recent case, and this is where now the courts actually had to make a determination actually. And not only that, just the concept of piercing the corporate veil, both in terms of common law and in terms of our statute, in relation to other provisions that are contained in the Companies Act. It's quite interesting, and at least hopefully at this point, this will be able to show you the difficulty, number one, but not only that, it'll show you how basically the courts approach this concept of piercing the corporate veil, or at least how the courts really work hard to preserve the concept of separate legal personality, also in effect protecting the members of companies. Ladies and gentlemen, here in South Africa, one thing that has been quite prevalent over the past couple of years is that there have been a number of cases of whether it be fraud or whether it be instances where it's quite clear that a company is used to evade, to evade liability. So people will then form companies, and obviously companies will operate as such. But obviously, because a company, yes, it's a juristic person, but I mean, obviously speaking, because it's not a person, it means that directors and the shareholders of the company, although they're not liable for actions of the company, they go and they act on behalf of a company, they transact on behalf of the company, and they do all sorts of things that are required on behalf of the company, but in the name of the company. And I think that is really important to take note of, because in the name of the company will then mean that obligations and rights then accrue to the company and not the members. Okay, so the case that I'm referring to this afternoon, it's the case of, it's an SCA judgment, like I've already indicated. It is on the internet, so you are more than welcome to go and research that case for yourself, have a read on the judgment and try and ascertain and understand. Maybe you'll get a bit of a better understanding on the concept of piercing the corporate veil and how the court, this is quite an interesting case actually, because this shows you how the courts not only wanted to look at the protection of the concept itself, and that is obviously the principle, the underlying principle of our company law, that being separate legal personality, but also having to consider how the courts approach instances where directors, for example, are negligent in representing a company or acting on behalf of a company, or shareholders, or whatever the case may be. But when a company is used to, for example, perpetuate fraud or reckless transactions on behalf of the company, or just so that they can evade that liability. But be that as it may, the case that I'm going to discuss this afternoon just basically shows you how important and how significant it is that courts try and preserve the concept, the underlying and foundational principle of our company law, which is a company is separate from its members. Now, I don't know if I said the case citation, but it's basically Veneta Africa, Pty Ltd versus Watts and another. So in this case, we've got a company as the appellant, and we've got two directors of company B. So I think maybe for better understanding, I'll try and explain this case in a, not in a legal way. I'll try and make it as understandable as possible, just so we can all follow, but we can all see how the court looked at it, how it interpreted provisions of the Companies Act to make a determination as to whether or not it was justified to pierce the corporate veil in the circumstances. So, ladies and gentlemen, like I said, I think we will, I think the citation will be provided to you guys upon request, obviously, if you guys need the citation of the case. But effectively, so there's a plaintiff. We'll start maybe by giving a background fact of what happened, particularly in this case. Okay, in the High Court, so there's a company. This company basically, part of the services that it provides is services of basically forwarding, right? Basically forwarding. So there's a company, and that's the appellant that is bringing this action. There are two directors that are being sued in their personal capacity. And the reason for that is because these two directors are directors of a company whose purpose, and obviously it's incorporation, whose purpose to provide services that were then not provided in the way that was at least agreed upon between the creditor, who's now the appellant in these proceedings, and the company, who were represented by the two directors cited in this judgment. So I hope that makes sense, and I hope that's easy to follow. But the essence of this case simply is that, right, there was a breach basically in the contract between the two companies, between basically the creditor will, for purposes of easier understanding, we'll say the creditor and the company represented by two directors. So I hope I'm not just all over the place, but nonetheless, so there's the creditor and there's the company represented by two directors. So obviously the creditor got into the transaction with the company. And yes, it was represented by the two directors, but the essence of it is that the transaction is itself, or the parties to the transaction, was the creditor as well as the company. Now, the problem became now when there was a breach, right? There was a breach, and because of that breach, the appellant who brought this action then came and actually sued the directors of the company. Now, with this, what of particular interest in this matter is that in suing the directors personally, they sued the directors, or the, if I may put it, the legislative provisions that they relied on to sue the directors personally was the provisions of Section 218 of the Companies Act. Now, Section 218 of the Companies Act basically regulates and says that anyone who breaches or who acts contrary to the provisions of the Companies Act can be held liable. That's the first thing. And the second thing basically had to do with them saying that they wanted to bring an action for fraud, but that's not the basis of our discussion this afternoon. But rather, I want us to focus, number one, on the aspect that the parties to the transaction was a company and a creditor. A company was represented by two directors. Now, what the court did in this matter, right? Sorry, and I think one thing I did forget to mention was that in bringing the action in terms of Section 218, that basically says anyone who breaches a provision of the Act is going to be held liable. They then also brought it in terms of the provision of Section 22 that says actually companies must not transact recklessly, otherwise they will incur liabilities. So there's those two provisions. Now, in the first, the quota quo. In the quota quo, when this action was brought, obviously the summons were issued, the particulars of claim would then obviously outline the basis of the cause of action. And they said, well, Section 218 says anybody who breaches the provisions of the Act must be held liable. So in so doing, who did they cite? They cited the directors of the company. That's the first thing. The second aspect is that in so doing, they also then said, read the provisions of Section 218 together with the provisions of Section 22. Like I've indicated, Section 22 says any company that basically transacts recklessly will be held liable. I'm just going to keep it that simple, just for the basis of being able to understand. I know it can be a lot to follow all at once, but nonetheless, in the first hearing in the quota quo, the courts basically, okay, wait, I've actually just described what was in what provisions the action was brought, but in responding, the defendants actually said, no, hang on, you cannot be bringing Section 218 and Section 22 of the Companies Act to impose liabilities on the directors. Why? The first thing that they did say, that they did argue, was number one, Section 22, if you look at the provisions of Section 22, they refer to a company. And a company, as we know it, as we've discussed in the preliminary parts of our discussion, a company is separate from its members and its members, that being the directors and the shareholders. And as such, they argue that, well, so you can't come and say you're holding us liable. Otherwise, that would be contrary to the provisions that basically speak to the concept of separate legal personality. Now, Section 218 basically, like I indicated, says anybody. Part of their argument was that, well, it says anybody can be held liable if they breach any provision of this Act. And again, that was argued by saying that, well, in looking at the provisions of Section 218, we've got to look at them from, we've got to exercise interpretation with that. And what that means, we must look at the Act as a whole, and we must look at the intention of the legislature in actually drafting the provision the way that it was drafted. And also, to give effect to that provision, we must also consider whether or not this would also would contradict another provision in the Act. And in the circumstances, if we applied strict interpretation to the provisions of 218, that would simply mean that, yes, it would contradict other provisions of the Act. Now, if you didn't understand what I just said, I'll just break it down, just to make it a bit more clearer. So in essence, they like I said, the creditor brought the action in the court of law and said, listen, I want to hold the directors liable for breach into, let's just say breach of contract, just to keep it at an overview perspective. They said that, well, we actually want to come and sue the directors of the company. Then in response, the director said, well, you can't sue us because we're protected. We're protected by the concept of separate legal personality because we're not the company, we are the members of the company. And as such, the founding principles of company law actually dictate that no, we cannot be held liable. They also said, even if you look at the provisions of Section 22, the provisions of Section 22 say you hold a company liable for its reckless lending. As such, again, we're going to refer to the provision, the founding provisions of or principles of company law that says that a company is actually separate from its members and its members being directors and shareholders, and therefore they are protected. So basically that was the argument at the Court of Appeal. So the matter was taken on appeal, and the SCA then looked at how it wanted, or at least it outlined in its judgment, how it would approach this whole, or at least adjudicate this entire matter. And before it did anything in terms of interpreting the provisions of Section 218 or interpreting the provisions of Section 22, it said, wait, hold up, let's actually go back to the basics. So again, it went back to the provisions of Section 1 of the Companies Act that say, what is a company in terms of the Companies Act? And simply put, a company is a juristic entity incorporated in terms of the provisions of, that Act 71 of 2008. And in so doing, then the court moved on to discussing the provisions of Section 19(1) of the Companies Act. Again, Section 19(1), what does that tell us? Section 19(1) just simply says, upon incorporation, a company becomes a separate juristic entity. It's capable of acquiring its own rights. It's capable of incurring its own obligations, and it is liable as such for those obligations. Then we move on to the provisions of subsection 2. What does subsection 2 say? Subsection 2, and that is of Section 19, by the way, it again fortifies the legal principle of limited liability. Directors and shareholders are protected from personal liability or incurring personal liability as a result of the wrongdoing of the company. So that's firstly what the court, at least the SCA at this point, did when it then looked at how, or unpacked the legislative framework of how it would approach the facts that was before it, having considered obviously the judgment in the Court of Appeal. I hope I'm not going too fast. I'm actually a bit nervous about going too fast, but hopefully everybody is still with me. And if that is the case, then we will just look at then the court went to discussing the provisions of Section 20, subsection 9. And like I'd indicated, if you'll recall, I said in our company law, when it comes to the concept of piercing the corporate veil, it takes twofold. It can either be in terms of common law or it can be in terms of statute. Now, in this judgment, the court basically then looked at the provisions of Section 20, subsection 9. And why is that? Number one, because if you will consider the relief that was sought in this particular case, it was liability of directors. And if, once again, we go back to the founding principles of company law, if you're going to hold directors liable for the wrongdoings of the company, the essence of that is simply put piercing the corporate veil. So like I said, if we go back and just to give a structural overview, we've got a company, and upon its incorporation, it becomes separate and distinct from its members. Once it becomes separate and distinct from its members, we've got the veil that's created to create that protection and that distinction. What that means in terms of Section 19 means that you cannot simply go and hold a shareholder or a director personally liable for the wrongdoings of the company. However, notwithstanding that, that is the general principle in our law, then Section 20 comes in and speaks to the exception to the general rule, which is now the statutory piercing of the corporate veil. So with that being said, the courts had to determine whether it would be justified in this instance to actually pierce the corporate veil, actually also considering against that backdrop, if interpreting the provisions of Section 218 to mean that the court would be justified, and read with Section 22, would in essence be the just and equitable remedy. So like I'd said, when we got to the SCA, or when the matter got to the SCA, the court, before even going into interpreting those provisions, because the remedy that was sought was brought in terms of those provisions, the court went back to the basics and said, what is a company? Section 1. Then it said, what is the status of a company? Went to the provisions of Section 19. Then it went to the provisions of Section 20 to say when a court can actually declare and, pierce the corporate veil by declaring that a company is in essence not a juristic person, but rather should be considered as one and the same with its members, the effect thereof being that the members of that company will be held personally liable. Now, only after the court considered that foundational basis of company law, that being the general principle and the exception, did the court then go and interpret sections 218 and sections 22 of the Companies Act to ascertain whether or not, in actual fact, a case was made out to, for the relief sought to hold the directors and those two directors rather, personally liable for the breach in terms of what was required from them by the contract. Excuse me. With that being said, I'm just going to go into what the court said basically, and how it interpreted these two provisions. And I think before I go into that discussion, just a general overview in applying the law, a lot more often than not, even if we are just interpreting provisions of different pieces of legislation, it's always important to bear in mind that courts will always try and give an interpretation that will not, or they at least guard against interpreting provisions to the effect that they will contradict other provisions of other legislation, or not just that, contradict provisions of the very same legislation. And so in so doing, it had to consider the provisions of Section 218 and interpret them to ascertain whether a strict application or a strict interpretation of those provisions would actually give effect or would get to a just outcome. And in so doing, the court said, the section itself, right, it doesn't create liability, but rather it imposes liability. In creating that right of action or imposing that liability, this provisions, and by the way, I'm referring to Section 218 in case you may have missed it. The provisions of Section 218 to give effect and to protect the general principles around what legal personality and limited liability entail, which are the foundational principles of our company law. The courts wanted to preserve that. And by so doing, that was obviously considered in interpreting the provisions of Section 218. So when the SCA found that, well, this section actually creates a right of action, it then further provided that, and in so doing, it didn't mean that by creating a right of action, it also regulated who it creates that right of action for and against whom that right of action is actually created. So if I can break that down, it just says, well, this section just says anybody that contravenes any provision of this act. But that's not to say by saying that we're just going to broadly apply this principle and just then disregard other provisions that actually properly regulate, what's at the core of these proceedings. Number one, directors. If we go to the provisions, and again, that's not the core of our discussion today, but just to give you a bit of an idea, if you have regard to directors' liabilities, it's regulated elsewhere in the Companies Act. It's regulated in terms of Section 7 of the Companies Act, where there are certain instances where the courts will actually hold a director liable. For example, a breach of one of the fiduciary duties to act within the best interest of the company, but that is regulated in terms of Section 77. So in bringing an action or an application, you can't then come and rely on the provisions of Section 218 to impose liabilities on a director when that is in essence regulated in terms of Section 77 of the Companies Act. So that's just one example. So that helped the court to interpret, to say, actually, yes, we hear that. Yes, it's quite evident actually in this instant that in breaching the way that the contract was breached, the directors of the company ought to have acted in a different manner. And you could easily argue that there was a breach of the fiduciary duties of those directors, but the act and the particulars of claim in the court of quo said, this action is actually brought in terms of the provisions of Section 218, read with the provisions of Section 22 of the Companies Act. So now we go to the second leg of the interpretation exercise that the court had to employ to come to its finding, and that is the provisions of Section 22 of the Companies Act. And that's, well, basically that section just guards, like I'd indicated earlier on, broadly speaking, it just guards against reckless transacting by the company itself. And it says, should a company be found to have acted recklessly or transacted recklessly, then the company will be held liable. And that's a non-brainer, considering that in our discussion earlier on the founding, obviously the foundational principle was that a company is separate from its members. So Section 22, once again, also didn't help the case of the creditor in this sense. Why? Simply put, because it's very clear and it's explicit by saying that liability will be imposed on the company should it be found that it was actually transacting recklessly. So in essence, what am I saying? Well, in as much as the action that was brought in the court of quo was brought in terms of the provisions of Section 218 and Section 22. And when that was interpreted, it was interpreted against the provisions of the foundational principles of our company law, which obviously speak to the fact that the company is separate from its members and its members, which are the directors and the shareholders. And that in essence creates the limited liability and protection afforded to directors and shareholders of a company, right? Before it even went into interpreting those provisions, that's what the court considered, because the court had to uphold those principles. And in interpreting the provisions were interpreted bearing in mind the foundational principles. And in essence, then the court actually found that the appeal had to be dismissed on that basis, that in actual fact, the statutory provisions that were relied upon to bring this action were not the correct ones, or at least were flawed in our law, which is part of what the arguments that were advanced in the court of quo. So in essence, ladies and gentlemen, I think having regard to our time constraints and having regard to maybe the need for people to ask questions at the end, which as I'd indicated earlier on, would be done at the end of this segment, I will just maybe conclude by then giving that broad overview once again to say that, number one, the concept of piercing the corporate veil in our jurisprudence is one that still needs a lot of development, and the first thing being, or the first reason for rather being that it's a concept that doesn't have a unified approach. You'll recall that I spoke about common law piercing and I spoke about statutory piercing, but my focus was more on statutory piercing, that being because it's easy to refer to a piece of legislation to ascertain whether a court would be justified. But again, even considering that, difficulty comes into play when the court must consider, at least insofar as the concept of piercing the corporate veil is concerned, difficulty comes in when the court must consider or at least define or establish what the concept of unconscionable abuse is, because the provisions of Section 20, subsection 9 say that if a court comes to the conclusion that there has been in the creation of the company or the use of the company or in actions on behalf of the company, there has been unconscionable abuse, then the court then may declare and may still also is an indication that the court is still actually able to exercise its discretion in coming to a conclusion as to whether or not the court will pierce the corporate veil. So it remains quite a, quite a broad concept, a concept where there are various instances, and some of the examples, if I may just give you another, another perspective of understanding insofar as why this concept is such a gray area. It also applies in contexts or instances such as in groups of companies. Now, those that may know what the concept of groups of companies entails in our law, it's basically the relationship between a subsidiary company and a holding company. And obviously that is established once certain requirements are met. But the long and short of it is, even in settings such as those, there are instances where courts will pierce the corporate veil. And those, again, are left to a very large or significantly left to the discretion of the courts, depending on the circumstances of each case. Also considering that our common law actually tries very hard to preserve the concept of separate legal personality as the founding or foundational principle in our company law. So with that being said, I do hope that there's some light shed into this concept of what piercing the corporate veil is or what it entails. But more than anything, I think it's quite important for people who would want to pursue litigation in whatever matter that may be litigious or that may require litigation, but be careful of, especially in the context of companies, and when companies are the ones that are actually instituting the legal proceedings or whatever the case may be. It's very, very important to firstly be aware that a company is not its members. That's important particularly because it should inform in terms of which provisions you're bringing an action or an application against a company, or if you are a company yourself instituting those proceedings or a member of a company. But the long and short of it, to make it again, to try and make it understandable, is that guard against the, what provisions you rely on in terms of bringing actions against companies or the members of a company, because a company's liability is different from a director's liability. And equally, a director's liability or a shareholder's liability in terms of the interests of a company, they differ. They're regulated differently in terms of the various provisions that are applicable in the Companies Act. And as such, it's very, very important to ensure that in bringing or instituting legal proceedings against companies or their members, that you rely on the correct provisions, but more so also to give you an illustration of the difficulty that courts face in applying this concept, or at least exercising their discretions to determine when this concept is best applicable, remains a mystery actually in our jurisprudence, and it remains a ground for further research, further comparative analyses, and so forth, because even in terms of our common law, the various cases have made various findings, and even in trying to establish guiding principles as to when the courts may pierce the corporate veil, it still is that our jurisprudence remains sort of in the gray area when it comes to the application and the ambit of this legal principle. So without wasting any more time, I think I will give the floor to my colleague to just take questions to the extent that we can, having regard to our time constraints.
Okay. Thank you very much, Samantha. I've really learned a lot from that. I do have a question myself, but I will just check if there are any other questions. And I think Tabiso in the chat box wrote quite a long comment. Let me try to see what he says or she says. As you have already alluded, that one of the instances where personal liability on the directors of a company can be imposed is when the director acts in the name of the company, signs anything on behalf of the company, which purports to bind the company, despite knowing that he or she lacks the authority to do so. He or she will be personally liable for any loss, damage, or costs sustained by the company as a director. For argument's sake, let's say the director acts in good faith on behalf of the company without authority to do so, and his or her action then benefit the company immensely. Can the said director demand compensation for his or her actions? Don't you think it's unfair, I think, for directors of companies to be held liable only when their actions seem to have been impoverished the company, but nothing happens when those actions benefit the company? So I think he then wants an understanding out of what happens in the reverse when there's no reckless or negligent actions done by the directors.
Okay, thank you for that question, Tabi. So I think that first and foremost, that question speaks to duties of directors. I think the best way or the best suited way, in my view, to answer that question would be to then obviously go into the assessment of the duties of directors. Well, first and foremost, a director's, I think the most important, or one of the most important duties or fiduciary duties of the directors is to act within the best interest of the company. And as one would imagine, that entails acting in a way that will benefit the company, whether it's in the form of transacting or whether it's in the form of making decisions on behalf of the company. So one of the foundational principles insofar as looking at the duties of directors and how the Companies Act regulates the fiduciary duties of the company, of a company, the first and one of the most fundamental things is, as a director, whether non-executive, whether executive, that's a discussion for another day, but primarily a director, as part of its fiduciary duties, must act within the best interests of the company. And part of that entails to make sure that, the company benefits from when directors act on behalf of the company. Because even when you look at part of, and you dissect that, it goes into the aspect of the day-to-day transactions, or how that is regulated. Also, it's important to look at the company's MOI, which is also known as the constitution of the company. That will also speak to the extent or whether it's authority or capacity to represent the company. But I think in essence, if you do well, or you represent a company well, or you benefit a company by representing it as a director or in the capacity of a director, you'd merely just be fulfilling your fiduciary duties to act within the best interest of the company. So I do hope that answers your question.
There's no other comment. Isn't that when the director would then get that incentive through the share? What's that? The director share at the end of the financial year from their profits. Isn't that would benefit them?
So, okay, in terms of their benefit, the declaring dividends only makes reference to what shareholders can actually then, how they can have proprietary interests in respect of a company. But in so far as directors are concerned, yes, directors do get some form of incentives, obviously depending on what the agreement is between the company and the director, and also considering over and above that, whether the director is actually part of the company as an executive director or a non-executive director. Like I've indicated, there are different duties, different incentives, different obligations for different directors, because the Companies Act also does recognize the various types of directors and what their duties are. In actual fact, that can actually be a whole conversation and a whole discussion on its own, because like I'd indicated, and I think somewhere in my discussion, I did make reference to the provisions of Section 77 of the Companies Act that also speak to not only what the obligations of the directors are, but also to some extent regulate incentives that may be, that may be obtained by virtue of someone holding the office of being a director. But I think more than anything, there's a very big responsibility on a director. If you take or hold office of being a director, there's a responsibility that comes with that. And primarily, as I've indicated, primarily speaking, that would speak to making sure that in everything that is done in the name of the company or in their representative capacities, it's done within the best interest of the company. I think, I hope that answers your question.
Yeah, I think Thabiso might be answered. Let me see if we have any other hands. Okay, I don't see any. Then I guess as the host, I can ask my question. Thank you, Sam, for the case discussion. And I'm just trying to understand this concept a little bit better, just in case I'm faced with a brief, I'm calling it out in the universe, that has to deal with a situation like this. Because I see from this case, the plaintiff sued the directors personally. And one of the directors then brings an exception in that because the company is a separate legal entity and has a separate legal personality, cannot be sued in their own names, right? And that's how it then goes to the SCA and. Then I go back to the section 29 of the Companies Act.
Right.
It makes reference for an application. So is section 29, as we read it, for an application of interested persons to, you can make an application for, what is it? Something about constituting unconscionable abuse of the juristic personality. Is that a separate application that one has to pursue? Or can, like in this instance, when you think that how the company is handled amounts to this term unconscionable abuse of that company, if I see that is happening, what do I do? And this company owes me. Do I then, like they did in the Renetta case, bring the action and in my pleadings cite the directors? Or do I cite the directors and then bring a separate application? Or something along those lines. I don't know if I'm making sense. Is it an application, a standalone application prior to instituting legal proceedings? Or do I have to just institute legal proceedings directly against these directors and then also rely on those other sections like section 218 slash read together with section 22?
Right. Thank you very much for your question, Tilly. I think I'll try and answer it well, to the extent that I understand what the question or the core of the question entails. So if you recall, in this case, basically, the creditor, if I may put it that way, sought a remedy against, or at least sought for the court to basically, in effect, the essence of the remedy that was sought was in effect to pierce the corporate veil. Now, the provisions of Section 20 say on application, which means, yes, you can actually launch an application to the court to say, to seek a remedy for the court to pierce the corporate veil. And in so doing, you then have to obviously look at the unconscionable abuse aspect. And like I had indicated, because it's not defined in the Act now, we're left to obviously utilizing the device of looking at it from a broader perspective, or how it would normally in the ordinary sense be utilized. That is referring to the phrase. So with that being said, obviously then the courts will then determine, looking at the circumstances of the case, and they obviously will differ from case to case, and ascertain whether it would be justified in piercing the corporate veil. But to answer, the long and short of your question is, yes, an application can actually be lodged in terms of the provisions of Section 20, subsection 9, because what you seek in that application is a declarator to the effect that the company is actually not a juristic personality, contrary to what the provisions of Section 19 say, which obviously, like I indicated, they say that, well, a company is actually separate, but in certain instances, then Section 20 kicks in, and it says actually on application, should a company find that unconscionable abuse has occurred, then the company can then pierce the corporate veil and make a declaration that the company and its members are actually one and the same, and in effect piercing the corporate veil to then hold the directors personally liable for the wrongdoings of the company. I hope that makes sense. But you cannot go and rely on another provision that, when interpreted, would actually then contradict or contravene the provisions that would specifically speak to the concept of piercing the corporate veil. So what I'm trying to say is that in employing the provisions of Section 218 and the Section 22, when interpreted to give effect to all the other provisions of the Act, the court found that it needed to not interpret in a strict manner, but in a manner that would properly give effect to the other provisions of of the Companies Act, also in effect guarding against ensuring that it would preserve the principles of our company law. So I hope that makes sense. But in essence, when we speak of piercing the corporate veil in terms of our statute, we rely on the provisions of Section 20, subsection 9. And whether that entails other things will obviously flow from whether or not the court would have found that unconscionable abuse has occurred, whether it's in the context of creating the company, whether it's in the context of using the company, or it's in the context of actually representing or acting on behalf of the company.
Okay, no, I am sorted. So, for some weird reason, I expected to find the words piercing of the corporate veil in the Companies Act. And I see that there's nothing like that. I see a hand by Thabo Modisanyane.
Thank you, Thuli. I'm trying to understand if there's a different form of doing the same thing, and I'm completely in the dark about can I stretch the meaning of piercing the corporate veil to apply to, we would know that the old Companies Act was is no longer in effect except for, I think it's the last chapter 16 or 14. It's from section 337 to 426. And that speaks to the winding up of a company. So the Companies Act of 1973. I recently did a meta and this particular section came up. When I went through it, it looked to me like in the process of winding up a company, the particular entity that is undertaking the winding up can recover some of the losses suffered by the company from delinquent directors who caused such a loss. Is this another form of piercing the corporate veil, or am I misunderstanding the principle?
So you would recall in the beginning of the discussion, so piercing the corporate veil essentially, not obviously, I apologize for that, but basically creates it's a metaphorical term used in company law, but that is just to separate the company from its members. Now, when you look at the duties of directors and when a director can be declared delinquent, it may very well have the effect of piercing the corporate veil, but then there's different approaches courts follow in that regard. And now that speaks to a whole different legal principle altogether. It's not in the general sense of, it's a company, it's its members, its shareholders, the directors, and they act on behalf of a company or they transact on behalf of the company. And then now there's there are now issues with, those transactions or whatever, or the protection of innocent third parties. The court now obviously then goes and looks at that concept or that principle of piercing the corporate veil in light of those circumstances. But when you look at regulation of how directors are either declared delinquent or what their obligations are, or what their responsibilities are, or how the Act defines the duties of directors, that's a completely different concept altogether. Because even if you consider how the court actually then approached the interpretation of Section 218 as well as Section 22, it did that giving effect also to the provisions of Section 77, which speak to the fiduciary duties of directors and when directors can actually be held liable. So there are separate instances where it just speaks to specifically the duties of the directors towards the company in various aspects. And in the event of the breach of those duties as they are defined, then that constitutes a breach of the fiduciary duties, and the legal consequences thereof that follow become different. So it's a bit of a much more narrowed scope and a narrowed perspective in terms of how the courts then obviously hold directors liable, as opposed to a wider concept of when courts can pierce the corporate veil. You'll also recall when I, in the discussion, I discussed it can also apply in contexts such as groups of companies where there's fraud, and can also actually overlap with the criminal sphere of our law, which makes it an even more difficult concept to really uncover. So with that being said, I think, yeah, that's the approach I would have taken to answer your question, and I hope that helps. I see there's another hand.
I don't know if Thabo is answered, but I guess.
Yeah, no, thanks to Lee, I am answered, but maybe I'll have a private conversation with Samantha, and it's because I understand the concept, but when the facts come sometimes, and maybe let me make an example. I get a brief from an attorney. There are particulars of claim, and when I look at the particulars of claim, for instance, my client is a company. The plaintiff is SIFA. SIFA wants to claim monies from the company, which monies were advanced in terms of a credit agreement, and a suretyship was signed. But in the alternative, so they plead the contract, they plead everything, but in the alternative, they also plead something that at first glance, one would think that they're trying to pierce the corporate veil. But they then rely on Section 77 of the Companies Act to hold the directors personally liable in alternative to the contract and the suretyship failing. And when I went to go read up before I decided what to do, I realized that Section 77 is not available to third parties. It's only available to other directors of a company to hold co-directors liable for the losses suffered by the company itself. So it's not available to a third party like SIFA, who was a creditor. But for me to be able to know in those circumstances, I wanted to understand, is piercing the corporate veil in the narrow sense, or is it a general term, or is it a general principle that can be employed even under 424 of the old Act or under Section 77, which is only available to the company? But I suppose I'm answered. Thank you very much, Samantha. But I have more questions. Thank you very much.
Thank you.
Yeah.
Thank you, Thabo. But I think in essence, you make a very important point by establishing a very significant difference between the provisions of Section 77, which are basically there to regulate the internal, basically. It's more internal than it is a protection remedy or protection mechanism for external parties or third parties, for that matter. So Section 77 as a remedy is a remedy available internally, where a director of a company can hold another director personally liable. And there's various, obviously, requirements that then will be stated to say, for example, if they were in a meeting and they voted in terms of a certain resolution that was then passed, only to find that, in essence, that amounted to a dereliction of their fiduciary duties, then the directors of that company can come and employ the provisions of Section 77 to hold those directors personally liable, and in essence, obviously, then sort of, seeking remedial action in that regard. But piercing the corporate veil is more of a protective measure for third parties, or it's more external than it is internal, because now a creditor, as in the case that I just discussed earlier on, it's an external creditor, someone who contracted with a company and then came actually seeking remedial action against the directors of a company by looking at provisions that, generic provisions of the Act that say, for example, Section 218 saying anybody that acts in contravention of the Act will be held liable. So that's when the court then had to come in and interpret. But I think the long and short of yours is, I think, that important distinction to say Section 77 and looking at the directors, their duties, their obligations, and how they can be held liable is more of an internal remedy than it is an external remedy. And we can definitely have a further discussion if you still need further clarity.
Yeah, I think he's answered. I also see a hand from Mdu.
Thank you, Thulelo, and thank you, Samantha, for the enlightening lecture. I think I'm also answered. Yeah, what you just said, your letter answer, I think covered me. But just to be sure, let me pose my question nonetheless. in relation to directors, as you have told us, directors are they have their duties that are imposed by the common law and confirmed by the Act. So my question was that do you think we still need the remedy of piercing the corporate veil in relation to directors when we can merely pursue them for a violation of their directors' duties? I'm asking this because I assume in each instance whereby a court would be entitled to pierce the corporate veil, we can take it for granted that in that instance, the director would have violated his or her duties. So do we still need, specifically in relation to directors, the further remedy of piercing the corporate veil? Can we just rely on the violation of the duties? Thank you.
Right. Okay. So just to 100%, I think more than anything, yes, we do still need the concept, and yes, we still need to develop it further. Apologies for that. Our sensors are probably off. We use light sensors, but nonetheless, so remember when in the preliminary parts of the discussion, we indicated that so the separate legal personality aspect it's not just about directors, but it's directors and shareholders. In fact, it says it uses the broad umbrella term of not piercing the corporate veil, but rather members of the company. And members is not just directors, not limited to directors, but it's directors and shareholders, or any other member, really, depending on what the circumstances of the case is. So yes, there is still a very large necessity, actually, especially for the protection of third parties and on an external basis for the concept of piercing the corporate veil to apply. Why? Because then it allows, or at least affords, those third parties to have some form of remedial action in instances where it is justified to do so. And as such, like, it's important then to distinguish when it's appropriate to employ the provisions of Section 77 as opposed to the provisions of Section 20, subsection 9 of the Companies Act. There still is very much a need for, the use of both, because the different instances will basically inform when it's appropriate to use one as opposed to the other. It's not to say there are never instances that are going to be there where they can be used, I suppose, together, but to say that one can extinguish the other by virtue of holding the director liable will not be enough, because then the one speaks to an internal remedy by the other directors, whereas the other one speaks to the protection or a protection mechanism that can be employed and used by external or third parties. Thank you.
Are you sorted?
Completely.
Okay, but I see Nomsa's hand, but just to jump onto Thabo and Mdu's question, is it the test, inverted commas, unconscionable abuse, and like you said in your lecture, that it's always going to be difficult for the court to assess what amount to this. So yeah, I'm just leaving it there, that I think there should be a distinction between that. Was it what's the word, Samantha?
Unconscionable abuse.
Unconscionable abuse or not, and then for it to apply a Section 29. Okay. Bonga, Julissa, can you please mute your, she doesn't hear us. Okay. Nomsa.
Thank you, Thulelo. Thank you very much, Samantha, for the very informative session. We wish to have more on this area. I think we hardly interact with this area of the law. My question is more on a set of facts basis. And it's also, I think, a build-up or interlinked with the question raised by Mdu, and to a certain extent by Thabo as well. So if you have a set of facts where you have 3 directors, and they are all active in the company, and 2 directors decides to go and obtain a loan for the company, and the loan is approved. And at the point of repayment of the loan by the company back to the creditor, the one director then objects to repayment on the basis that actually that loan, when it was obtained, the other 2 directors were no longer registered on as directors of the companies. They did not obtain a proper resolution to go and obtain the loan and so forth. So the sets of facts are much broader, but I tried to summarize them. What I want to pose as a question is, in that instance, or in facts that are almost similar or related to what I have said, is it advisable to go the corporate veil, lifting of the corporate veil process, or rather just follow a criminal case route? Or does the piercing of the corporate veil apply in that set of facts at all?
Okay.
Yeah.
I think sure. I think there's a lot to uncover on just that question alone, because some of the elements of your question pertain to the capacity and the authority. It speaks, well, at least in the context of company law, which is a completely separate discussion altogether. But I think from the top of, from what you've indicated, the first thing I would obviously look at and dissect, was this person a member of the company when the loan was entered into? Because now, if we have to, for example, there may, like I'd indicated, I can only imagine, and I am subject to correction, but there may be instances where there may be an overlap in the provisions of Section 77 that speak to the fiduciary duties of directors, and then, certain principles or aspects of piercing the corporate veil. For me, where we speak of them entering into a loan agreement on behalf of the company, right, when they were actually directors. And remember, in the liability of directors, by the way, if I can remember correctly, and I will verify this, with the liability of directors, it doesn't just speak to directors at the time that they were directors. It speaks to current and past directors. So their liability isn't only limited to the time that they were directors. Even way after that has happened, even when remedial action is sought, it can be sought in a capacity when they were actually still directors of the company. So that's the one aspect. The second aspect is, looking at the provisions of Section 77, the second aspect can deal with those internal remedies. Like you said, there might be an overlap with what Thabo had asked together with Umtu, but that would then speak to the remedial action of the internal members of the company, speaking to the other director who can also seek that action against the 2 directors who went and did that on behalf of the company. And in essence, holding them then personally liable, jointly and severally so. Then there's the aspect of, then can you actually go the piercing the corporate veil route? I suppose on the one aspect, it might depend on who is seeking that action. Is it the director itself, the other director, or is it an external third party, that being the creditor to obviously the company? So there are a lot of aspects to uncover or unpack in answering that question. I don't think there's a single way of answering it, but nonetheless, you can explore various provisions, and in so doing, actually claim in your remedial action things in the alternative, if that can be of any assistance. So that is my long and short answer. I hope I've answered your question, Nomsa.
No, thanks. I think we'll have extended discussions outside this, but yeah, you did point to at least a route that one could explore in that. I was merely raising it from the point of view of the creditor who'd want to get his money back, which he has lended to the company, or under the pretense that it's being borrowed by the company. Yeah, so but it's fine, we'll sort it out later. Thank you.
You're welcome. Do we have any further questions?
I don't see any other questions. I guess Thabo and Nomsa have the privilege of having further discussions with you. Post this, let me switch on my camera. Post this lecture, but I think I speak for all of us. Samantha, thank you so much for taking this afternoon to teach us. Me, more so, I learned a lot through this. Companies Act is actually quite a very long act. There's certain intricacies, I guess, that go with it. Who do we sue? When do we sue them? When do we pierce this corporate veil? When do we lift? I don't know if lifting and piercing is the same thing. Piercing the corporate veil and learning the word unconscionable abuse, but I think there's a lot that we've actually learned through this. Yeah, so on behalf of PAVASA and its members, I would like to thank you very, very much for taking time and unpacking this for us. And I see also there's some of our colleagues in the chat box who are also extending their gratitude and saying thank you for a very informative session, Advocate Samantha, and simplifying this lecture. It was very informative. Thank you, colleagues, for joining us each and every month for our monthly lectures. Please keep joining us, and please, we now have a YouTube channel. I don't know if it's a channel, but we do post our lectures on YouTube, just in case if you've missed it. You can find them on our YouTube, like and subscribe to our channel. But thank you. Enjoy the rest of your evening.
Thank you guys so much for the opportunity. I do greatly appreciate it as well on my end.
All right. Thank you.